All right, I show you registered to testify as David Griggs on behalf of yourself on the revised congressional redistricting plan. Is that correct?
That's correct, Mr.
Please
Chairman.
give us your testimony.
Good evening, Mr. Chairman, members of the committee. My name is David Griggs from Dallas County. I'm an attorney currently in private practice, a former civil prosecutor with the FTC, a longtime adjunct professor of political science at Dallas College, and currently an adjunct professor of election law at the University of North Texas, Dallas College of Law. Today, I am here representing myself. It is from my experience in teaching election law, specifically, that I have studied the concepts of partisan gerrymandering and race and redistricting, and it's from that that I draw my comments today, opposing this mid-decade redistricting effort. I agree with the public comments of many of my fellow Texans who've previously testified regarding the ill-advised nature of this process. But the main point of why I'm here tonight is to reiterate some of the comments and testimony we've already received from other law professors and legal experts that the Department of Justice letter is a deliberate misrepresentation of case law governing these issues and should not serve as any kind of legitimate justification for the reconsideration of district lines. There are three cases. Most of you have read this letter. Three cases that are listed. First is Allen versus Michigan. This was a case that upheld the applicability of Section 2 of the Voting Rights Act when Sections 4 and 5 were decimated by the Shelby County versus Holder case in 2012. It was widely hailed as a positive case for the future of the VRA and its enforcement of Section 2. However, DOJ lawyers distorted dicta in a concurrence by Justice Kavanaugh to twist it around to support their concept of race-based gerrymandering, and even said that it would require a compelling state interest for Texas to keep those districts. This is an absurd argument and a serious misreading of the majority opinion. The second case was Pettaway versus Galveston County. That was a Fifth Circuit case where the court expounded on coalition districts and what it takes to make a successful claim to challenge them. It does not have anything to do with the unconstitutionality of a gerrymander. It merely asserts that the VRA in this circuit only, the Fifth Circuit, does not allow individual racial or ethnic groups to join together to claim that the maps dilute their votes. The circuits are split on that. It does not say that coalition districts are not allowed. And finally, the last case, Bartlett, also misrepresents.
Mr. Griggs, 1 second.
Do you have a question?
So your time has expired, but I have a question for you.
All right, please.
I think he wants to ask you about Bartlett.
I'm actually going to ask you about the last case
Okay,
first.
now you can answer.
Mr. Chairman, may I answer the question?
I think you can only answer. But he's
So
gonna,
I'm asking you the question.
Yeah.
To please explain the last case. And then I'm...
All right.
There we go.
Thank you, Mr. Vice Chairman. The Bartlett case determined that a minority group must meet a numerical test of more than 50% of the population to allow what was in that case a crossover district. That's not what you're here to consider, and that case doesn't apply. It doesn't consider the permissibility of coalition districts or crossover districts, and it even states the following. It states that states who wish to draw crossover, or in this case coalition districts, are free to do so where there are no other prohibitions. So the case was completely misrepresented, and my whole point is that if this was the justification for the governor's call, it is totally bogus and it has absolutely no purpose here, and I think you all should find another justification because it's not this. Thank you.
I do have one more question, if you don't mind.
Sure.
I understand. I believe that the DOJ letter, besides misrepresenting the law, and remember, I'm a lawyer. I'm an engineer, not a lawyer, so I need advice. But it is my understanding that what they are asking us to do is actually illegal.
That is correct.
Can you please help me understand that?
Sure. Well, the Supreme Court, by the way, has not weighed in on the Pettyway case. You got to understand that. It's only in the Fifth Circuit, and the circuits are split. And so if you look at all of case law, it is not likely that the Supreme Court is going to take the Pettyway, which is really what they are putting here. And that's the only reason they wrote it, is because there was a 2024 decision that was a circuit decision. It wasn't even the entire country. And they're assuming that the Supreme Court is going to take that. Well, even if they do, there is other case law which says that you cannot do this. You cannot take districts that were drawn that were race blind and then use a race-based theory to undo them. Even our Attorney General has testified that it was legal.
And actually disputed. So you're right. I got it. So the Attorney General has backed up this claim. But let me just boil this down into something that my
And of
feeble
course, he
brain
would
can
only tell
understand.
you the truth. You know, that's you got to realize that.
The
right?
DOJ letter claims that districts were drawn on the basis of race, which is untrue according to the people that drew them in the first place. And the DOJ letter then says, on the basis of race, you are to go after these particular districts, which is unconstitutional.
Right, right.
Help me make that make sense.
The whole premise of this letter is wrong, and it was written by probably someone who had not passed the bar. And if you remember, Professor Katz testified to you all that if she had graded a paper that was written anything like this, she would have given that student a very bad grade.
Thank you for your testimony.
And as a former civil prosecutor for the Federal Trade Commission and keeping my interest in doing great work for the federal government, it is an embarrassment to read something like this, and it should not.
Thank you for bringing the expertise. I appreciate it.
Vice Chairman.
Members, any other questions for this witness? Chair Hazan, thank you for your testimony.